Hello, this is Matt on the Moon Family Sedan channel. You know, we here in the XRP community, we have a lot of highly intelligent and educated people, including a lot of attorneys. I want to share with you 5 predictions from a former attorney within the XRP community. And I'll even tell you here at the outset of the video a couple of the points that he makes, and then we'll get into the specifics as to why. But he's predicting that ultimately it's going to end up being the case that XRP itself will be found by Judge Torres to not be a security. And ultimately, this will lead to settlement. Now, I say settlement, but not before Judge Torres gets to her specific ruling having to do with the SEC's motion for summary judgment as well as Ripple's motion for summary judgment. So there's still some things up in the air here. Nothing's guaranteed, but the perspective that he's sharing here seems perfectly reasonable and pretty damn good. If it shakes out like this, we're going to be very happy XRP holders. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, and so here we have comments from XRP community member and former attorney Scott Chamberlain, and he shared a breakdown with his 5 predictions for how this is all going to shake out. And I do think everybody's going to be very happy with this particular analysis here, should it come to pass. And again, I personally, having gone through this, like I even responded yesterday, I think it was, I thought it was an excellent analysis. And so we'll see how it shakes out, but check this out. He says, with a decision in SEC v. Ripple seemingly nigh, I thought I'd do the stupid thing and predict 5 outcomes. Number 1, summary judgment for Chris and Brad. I don't think the SEC has anywhere near the evidence to support they knowingly or recklessly sold an unregistered security. Yeah, and so I'll just pause to note here already that seems to be the widely accepted point of view of pretty much all the attorneys within the XRP community. It seems as though, so you can ask, like, okay, why go after Brad and Chris? Because this is a non-fraud case. This is highly irregular. And I think the only rationalization that we could come up with to this point is that they were really trying to bring the hammer down and pressure these individuals into going the way that the SEC wanted to go. And they're just being vindictive, complete pricks about this. That's what it looks like, because this is so far outside the norm. I don't see how the SEC gets anywhere with this. Knowingly or recklessly sold an unregistered security, that's a really high bar from a legal perspective. And then he has his prediction number 2. And this is where it starts to get more, it gets increasingly more interesting as we go through the lister. So prediction number 2, summary judgment for Ripple in respect of overseas sales. Ripple's sales of XRP on overseas exchanges are not within the court's jurisdiction. A wholly new precedent would be set to deem those domestic transactions finalized in the United States. And so what he's noting here is that, like, in fact, I think it's the majority, in fact, of transactions, they were all done on exchanges overseas. Now, it just is a matter-of-fact point. It is the case that transactions that occur overseas are wholly outside the precedent of the SEC. Without question, that's it, period, full stop, outside. Now, the SEC is still going after this as though these transactions somehow broke securities laws in the United States, but it seems completely absurd on its face that Judge Torres could find that to be the case. So what Scott Chamberlain is noting here is that they're going to lose on that, on all those exchanges, all the transactions on exchanges outside the United States, because you'd be redefining, effectively, like what securities laws are here in the United States to have those happen overseas, but still have it count as being finalized in the United States, as Scott Chamberlain put it. Doesn't seem likely to happen from Scott Chamberlain's perspective. And then his prediction number 3, summary judgment dismissing the part of the case that asserts XRP itself is a security. Oh, yeah, okay, so this is one of the things that we most severely need to occur, just as XRP holders. Of course, Ripple wants that as well, but and I've said this many times, and I don't mean to sound cold at all. Not that I want Ripple to have a bad day or anything like that. I think they're a great participant in the XRP ecosystem. highly valuable, just great to have them doing what they're doing. They're the greatest cheerleader for the XRP ecosystem that there is. I think you could easily argue that. But even if they end up being found guilty of certain specific transactions, having been some sort of unregistered securities, illegal transactions, okay. But, as long as we get some sort of ruling from Judge Torres that XRP itself isn't a security, we're good as XRP holders. That's it. And then exchanges, in theory, should, and hopefully would, relist XRP promptly, because why the hell wouldn't you? Unless you're worried about, the appeals process, should that occur. And there's a lot of ways that this could unfold, and who knows what's going to happen with internal, conversations at some of these exchanges, but I'm just saying. And then Scott Chamberlain says, no precedent supports the digital asset itself being a security. This claim was a contrivance for the SEC not to have to prove each sale and to avoid the problem of overseas sales. Okay, so folks, and this is one of my pet peeves as it pertains to this particular case. The SEC didn't do what they would normally do in any case where they're acting in good faith. If you're the SEC and you're acting in good faith, what you cite is specific transactions that broke the law. The SEC didn't do that. They said every transaction that XRP is a part of, always and forever, past, present, future, was, is, and will be forever, and unregistered securities transaction of Ripple. That's what they're claiming. And so it's a lazy way out of this, and it's also a way to, if this actually worked out, if the judge falls for this, which I don't think she will, it's a way to increase your jurisdiction effectively without getting that power from Congress. So very bad if that happens. Now, I'm optimistic that it's not going to happen, but there's that. And then also, as he cited here, if you just say everything is an unregistered security transaction, well, then that's a way to get around what he was citing in point 2, this idea that transactions on exchanges outside the United States, obviously outside of their jurisdiction, but if there was actually a ruling that all transactions everywhere on the planet and forever illegal, well, that's how they'd get around that in theory. So Scott Chamberlain's predicting, and I don't see how this part couldn't come to pass. I think he's spot on here, or at least in terms of this ultimately being the outcome. He's saying here, once we get the immediate ruling, which we assume it's going to be immediate, having to do with summary judgment, XRP will be declared itself to not be a security, or some sort of wording that makes it clear that the secondary market transactions that you and I engage in, not part of this case. And that should, in theory, be enough to get XRP relisted. I don't know for sure if it will be, but it should be. So that's a big one. And then his prediction number 4. What proceeds is a limited case about whether any of Ripple's sales of XRP in the United States involved an unregistered investment contract. Ah, yes, indeed. So think about this. If XRP itself is deemed to not be a security, that's his third prediction here. So say that comes to pass, what is left for the SEC to even do? Well, what he's noting here, all that would remain is any of Ripple's specific sales in the United States. That's it. Not even the transactions overseas. It's just the transactions here in the United States. That's it. Which leads us to prediction number 5. And this, I would love for this to happen. Scott Chamberlain says, prediction number 5, because of points 2 and 3, the case settles. And again, points 2 and 3, the third one was the one about XRP itself not being a security. And then the second one was about transactions on exchanges outside the United States. So he says, because of those 2 points, the case settles. And he says, I happen to believe the SEC underestimated that most of Ripple's sales occurred on overseas exchanges through algorithmic trading. Once overseas and secondary market sales are excluded, there's insufficient meat left on the bone. So think about that is all that's left. If you're talking about no transactions overseas and secondary market transactions, Judge Torres says no. It's all you have is the minuscule number of transactions that were just here in the United States. And at that point, why wouldn't there be a settlement? In fact, Ripple would jump at that situation, because once you get to that point, and this is why he's confident, and I'm confident that he's confident, should it get to that point anyway, should it get there, is because Ripple said the thing that's stopping them from settling is that there's not a path forward for XRP currently. But if there is a path forward for XRP, that's all they need. That's all they're looking for. There's a path forward. They'll write a check today. They absolutely would settle. So and so if the judge insists that this is all that's on the table, is just these United States-based Ripple transactions of XRP, but nothing else, not secondary market, nothing. Yeah, you're going to see this thing wrap up really quick. So it does come down to what we see in this case. So like imagine this also. It could be the case that the Judge Torres, declares that secondary market transactions, of course, not part of this, so XRP itself is not a security, but she could also, as I've been mentioning in recent videos and attorneys within our community have been warning, there still could be a jury trial moving forward. But the important thing to understand at that point, even if Judge Torres says there needs to be a jury trial, if she's already ex-nayed all of these transactions that occurred overseas in the secondary market transactions, well, I don't think you're going to see a jury trial, even if that's what Judge Torres says has to happen, because you'd see settlement instead. That's the point. So even if we get to the point where Judge Torres, we wake up tomorrow and we see news, okay, well, Judge Torres finally made the ruling, and there's going to be this jury trial, but also there's clarity for secondary market transactions. At that point, I'm gonna be like, okay, settlement's around the corner. Because why wouldn't it? Ripple's only reason for not signing it is because of those secondary market transactions and the idea of XRP itself being a security. So if I wake up one day and see that news, I'm going to be pretty damn excited, to be honest with you, because I'll know what's coming next. It's going to be settlement. That seems like a virtual certainty at that point. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.